social and political commentary from a Christian male perspective.
Grace and peace, everybody. The other day I did a video looking at the possibility of Young Thug having his probation revoked. And we talked about that. We looked at and I thought it looked pretty bad. I'm not going to lie. I really did think that it did not look good for Mr. Jeffrey Williams, did not look in his favor. But I also pointed out that I think the entire probation situation as a whole was meant to trap him. And I do believe that that's what we saw. I think we saw that it was meant to trap him. We saw that it was meant to keep him in prison, even though he pled guilty to these lesser charges. He wasn't found guilty of other charges. It didn't matter. They wanted that brother in jail. Needless to say, as most of you all may have or may not have heard, Judge Whitaker has spoken up about this. So let's take a second and look at what Lady Paige Whitaker has said. All right, so the Superior Court of Fulton County, State of Georgia versus Jeffrey Williams. Order continuing defendant on probation. Upon consideration of the state's April 2nd, 2025 motion to revoke defendant's probation, which alleges a violation of the terms of and conditions of defendant's probation for having posted a picture of a particular law enforcement official with the caption, "Biggest liar in the DA's office," the defendant April 3rd, 2025 response thereto, and having reviewed the terms and conditions of the defendant's probation imposed by the court declines to revoke the defendant's probation based upon violation asserted. So, needless to say, Paige has stepped in, Paige Reese Whitaker, and has done what I believe to be the right thing. But you might be wondering, well, Jason, what did Jeffrey Williams, a.k.a. Brian Steele, a.k.a. Mr. Adams, what did they say in response to the revocation motion? Don't worry, we got you. Here it goes. Mr. Steele's response to the state's motion to revoke probation comes down Jeffrey Williams by and through undersigned counsel and hereby files this response to the state's motion to revoke probation in the above referenced case. In support of this response, Mr. Williams shows the follows. 1, on April 2nd, the state filed the motion to revoke his probation. The prosecution must place in writing, pursuant to the due process clause of the United States Constitution, as well as Georgia Constitution, the specific case, or rather acts that Mr. Williams supposedly committed in violation to his probationary sentence, as shown below. The prosecution's motion to revoke Mr. Williams' probation fails on its face to allege any conduct that Mr. Williams that would rise to the violation of probationary sentence, taken in the light most favorable to the prosecution's allegations in the motion revoke probation. This honorable court could not find, as a matter of fact and or law, that Mr. Williams violated any terms of his sentence. And there we go. Give some good squiggly line right there. Honorable Court Appeals of Georgia reverse the trial. Let me pull that full article in. Hold on one second. Right? Okay, let's do this correctly. The state's motion to revoke probation must allege conduct which, if proven by the preponderance of evidence, shows that Mr. Williams violated the terms of his probation in a specific manner charged in the motion to revoke probation. As discussed below, taken in the light most favorably to the prosecution, assertions Mr. Williams did not violate any terms of probation, and thus the state's motion to revoke probation must be dismissed at this time with prejudice. At a preliminary hearing, the unrelated case, the magistrate court ordered that no witness be shown on television while testifying, and a known blogger deliberately violated that court's order by posting on social media the photograph of investigative Viverito. This allegation has nothing to do with Mr. Williams. Shout out to Brian Steele. They're coming in hot. First, even the known blogger did not violate the magistrate's court's order as asserted by the state's motion to revoke Mr. Williams' probation because there was no image shown of the investigator Viverito while testifying in this unrelated proceedings. This allegation cannot support the revocation of Mr. Williams' probation. Mr. Williams amplified this blogger's act by reposting the image with the caption, "Marissa Viverito is the biggest liar in the DA's office." First, there is no suggestion that Mr. Williams knew that the magistrate's court's order not to show investigator Viverito on television while testifying. Second, the allegation asserts that Mr. Williams reposted the image and wrote the caption. This allegation does not, move over. This allegation does not violate the magistrate court's order or Mr. Williams' conditions of probation. Okay. I see what you're doing. There. Third, there is no violation of Mr. Williams' probation by reposting an image on social media or opining that investigator Viverito is untruthful. Okay, I got you. I see you. The prosecution asserts that Mr. Williams' repost went viral and unknown persons commented on same, which included supposed threats to investigator Viverito, her family, as well as the district attorney. Mr. Williams' undersigned counsel and all moral persons do not condone threatening another without justification. However, these comments on social media by unknown persons cannot be attributed to Mr. Williams in order to support the violation of probationary sentence. Okay, I see what you're doing. I see it. The state's motion to revoke Mr. Williams' probation then lists direct threats in attached examples. Again, this allegation did not allege any act attributed to Mr. Williams to support violation of the probationary sentence. The prosecution speciously alleges that Mr. Williams is conducting a calculated campaign of intimidation, harassment, and misinformation designed to undermine the legal process. Okay. The other baseless assertions, these conclusions do not support a motion to revoke Mr. Williams' probationary sentence, and the remainder of the state's motion to revoke probation is argumented without any substance to allege an illegal or unlawful act conducted by Mr. Williams. Okay. I mean, they got me with you don't know, he didn't know that he wasn't supposed to put it on TV. Okay, I can see what he's doing there. A revocation of Mr. Williams' probation involves the loss of liberty, which is a serious deprivation. All right, let's keep it going. Mr. Williams is entitled to due process of the law. Got to bring that law back in there and process it duly. Let's go. This honorable court may not revoke any part of Mr. Williams' probation unless Mr. Williams admits to the violations as alleged in the state's April 2nd, 2025 motion to revoke probation, or unless the evidence produced at the revocation hearing establishes by the preponderance of the evidence the violation. And we got that squiggly line right there. In the case at bar, in light of the most favorable prosecution's motion to revoke probation, Mr. Williams can admit to all of the allegations alleged and still not have violated any terms of his probationary sentence. Shout out to Brian Steele, man. They work hard. I love it. Thus, the state's motion to revoke probation is deficient. Therefore, Mr. Williams asks this honorable court to deny the state's motion to revoke probation without hearing. If a hearing is needed, Mr. Williams will be prepared. Shout out. All right. I still think Young Thug needs to get around some people that are wise in respects of how to move, and he needs to listen to his attorneys. Maybe I reach out to Brian Steele every time he thinks about posting something. But I have to admit, I see what they're doing. I see their point. I see their angle. And I agree. So I initially thought that Young Thug was probably in deep waters, but I forgot he had Brian Steele on his team rather, and they ain't let that boy go down. They ain't gonna let him sink. So shout out to them for that, and of course shout out to Judge Whitaker for making a tough decision, because I'm sure the pressure to just capitulate and go with everybody else was there. But shout out to her for making the right decision. Let me know what you think down in the comments below. And if you have not already, and you're not already a subscriber, go ahead and hit that subscribe button. Help us hit that goal of 50,000 subscribers by the end of April. Y'all, thank you so much for rocking with us, and I'll see you next time. And until then, everybody, grace and peace.